any Open Records or Open Meeting Act during that meeting. And she appealed to the Attorney General, and this is the letter that she has to them. And then I believe your next, well, let's see, that's my next one. Your next one is
the summary that we received today.
okay, is that what you all have in front of you?
No,
Your next?
they don't have it.
Okay. All right. Well, Trevor Coleman also sent a letter, which I won't go into all that. Anyway, he denied the same thing. And the Attorney General has sent a letter in response to that, and I'm going to read the summary. Hazel City Council violated the Open Meetings Act in failing to comply with all notice requirements codified at KRS 61.815 prior to holding its February 7th closed session. City Council also violated KRS 61.815 1C by taking final action during that closed session. However, the discussion of legal strategy with its attorney, which preceded that action, was authorized under KRS 61.810. Now, what that means is quite a bit of stuff in here. In fact, probably half of this are other cases which are very, very similar to what has happened in that meeting. In explaining it, the first one where it said we failed to comply with all notice requirements, I'm going to take the responsibility for that one. Because, as you all know, we go into closed session. I do three things. I read off three things which give us the authority to be able to go into closed session. One is to give the general nature. The second is the reason. The third one is to list the KRS statute which authorizes that. In my first four and a half years ago, when I first started, it was brought to my attention through Goff and Ms. Green that I did not read the actual KRS number. Although I did state that it was authorized by the KRS, I did not read the actual KRS number. And so from that point on, I've always done that. However, now it is based off of several things that's happened through the court system. The book that I have to do more than that. I have to be able to give, in the general nature, I have to say that it is in regards to not just litigation, which in this scenario is the only litigation against the city. However, they want us to be very, very clear about this. And I understand that when you're dealing with something that's like this, it should be very open and very understandable. So in the future, I will say that it is Goff. The court, the litigation is Ray Goff versus City of Hazel. And I will probably also give the case number of the lawsuit that they have against the city. So I'll take care of that. And then when it comes to the other part, I will give the general nature or the reason. I will say to discuss legal issues that we do not want to have an open session because it would not be good for the other party to know what our positions are. So in that respect, that takes care of the first one, and your humble mayor will continue to add. I will write that in my book right here, and I'll have that in there. The second part, which was brought up, was in regards to whether or not we voted or not. The Attorney General has stated that based off the information that was given, that a vote was taken. And again, we are going to correct that. So we're going to get that corrected. I still maintain that if the seven of us had gone to the attorney's office and he had asked you all the same thing and put those papers in front of you, same thing would have happened. However, this was in a closed session, And so therefore, we should have perhaps done it differently. And so we're going to correct that, because we want to be able to make sure everything's on the up and up with the council. And
Let me just say one thing.
Sure.
I would have bought the argument that it was just for our attorney if it was not a decision that was passed from our attorney to another attorney as a action in a lawsuit. The idea that it was just a vote for our attorney makes no sense whatsoever.
Well, Mr. Yeah,
It
okay,
was a mistake.
yeah, your point is taken, and the Attorney General agrees with you. And whether or not me or anybody else agrees, the Attorney General's opinion is the one that we want to go with on this. We want to be on the up and up.
Mr. Mayor,
Yes.
was it made clear to the Attorney General that no motion was made, therefore no vote?
Yes.
You cannot vote without a motion.
Yes. The one thing that probably, I'm not going to read this whole thing to you, but it was brought out in Megan's letter. Mr. Coleman regrets using certain language back when he was doing it to the other attorney, Mr. Haverstock, saying that the council unanimously voted. He said it was a poor choice of words, and it was certainly not good for the city's benefit for that wording, but not throwing anybody under the bus. I think that was, it's terminology, and either way, if the appearance or the actuality of us voting or information, it comes across that way, and that's why you have brought that up. So what I'm going to ask for is, make sure I read this right. I'm going to need someone to give a motion for a vote to set aside any action that may have taken place in closed session at the February 7th, 2011 meeting.
I make a motion that in the February, what?
7th.
2011 meeting, any perceived vote that was taken, we set aside.
Second.
Second, all in favor?
Aye.
And motion carries. Now, maybe to be able to address fully your concern on this, and correct me if you'll help me on this part. We want to do this in open session, because we've just now rescinded anything that was done there. And so now to be able to address your concern, what we considered then, we want to be able to consider it again. And does that meet the concerns that you had regarding this?
I think, yeah.
Okay, all right. Because that's what we want to do then. And I want to do an open session. Trevor, I spoke to him about it, and I feel comfortable about it, and he feels comfortable. So, and the latest, I'm not sure I don't get too far out of line here on this. Well, I got other stuff to read.
This right here.
Okay, good. Okay, from the Coleman, which one is that one? First or second?
This one, Carrie.
Okay. Yep, I've got it. Okay, prior to getting to that point, here were the two things that that transpired up to this, where this is from to Mr. Haverstock. He says, likewise, I personally sent the fax and personally called to verify that your office received it as regards to my letter March 9th, 2011. This is regarding the settlement that we had floated across to them. As such, it must have gotten misplaced. Also, if possible, please try to return my telephone calls on this matter in the future. I logged six different calls into my file before I was able to snag you recently while I was on vacation. I will be in touch with you in the near future and would like nothing better than to resolve this matter. Also, I have faxed and mailed this letter to you and may send it by carrier pigeon as well. And then...
Can I bring up something about that? I know you're just loving me right now, but let me bring up something about that. I got a letter from our attorney I got one hard copy sent regular mail. I got one certified mail, return receipt requested.
Oh, which one, which part are you talking about?
About from the Attorney General issue, I got a letter from our attorney, Trevor Coleman. Now, if he can send me 2 letters, one certified, return receipt requested, getting a receipt
Hazel
to
City
know,
Hall.
to prove that I received that letter, why can't he send one to Gary Haverstock
Hold on just
with
a
a little
moment,
receipt
please.
saying that, yes,
Good
this
question.
was delivered to him?
Now, when it comes to what you did on alleging a complaint, the laws, we have to be
Where
able
you
to,
located at?
within 3 days, respond, normally by certified mail. Now, I know you didn't do it with me, but you handed it to me, and that was fine. But they normally do it with certified mail, to
Yeah,
just show that the
sure.
person actually did get it, so.
Yeah, but since there's issues with receipt, why doesn't he have some proof that these things were actually received?
Maybe
This is
they
such
did.
an important thing. How are these things getting lost?
Maybe the attorneys are sending stuff back and forth. This isn't the only lawsuit they have going. They have stuff going back and forth all the time, and he maintains
Well,
he
I'm
faxed
sure
it.
he's very busy, but he wasn't too busy to send me one certified, so
But that's
Yeah.
different
it's
because,
a small matter, but
well, no, but when it comes to an allegation of an ordinance or open records meeting being violated, then that's a little bit more.
that's more serious than our lawsuit.
Well, if the KRS says you have to do these certain things, and that's what they do. The attorneys go back and forth, and I'm sure the other ones, they may all send them, some may send by mail, some may fax, some may email. That's between the attorneys and what they want to do, and I have nothing to do with that.
Well, he should have a fax printout that says, sent at such and such time.
Well, he
Something.
maintains that he personally called to verify. He told me he spoke to the lady
Yeah.
up there to verify that she received it. So.
That doesn't hold any weight. You and I both know that. But
That's
anyway.
something you can bring up with him, not me.
moving on. Well, I
Not me.
will next time I see him because I think it's silliness. But
You wear him out, then, that's fine. All right, now,
I don't have a copy of this letter that.
On your own time.
okay, this next portion, which was regarding our settlement offer, which was the portion about reducing or eliminating criminal penalties for non-compliance and loss of potential clients due to his having to reveal their names and addresses to the city. Bearing the above in mind, the city discussed in a public meeting held last night a proposal to amend the ordinance such that there be no criminal penalties and further to permit a business owner to deliver the names to the clerk but without their addresses. The listing of names could also be verbal. This would alleviate both of Mr. Goff's stated concerns. That's the one that we said we got no response from. That's the one that they said that they did not receive. And then from Mr. Haverstock to Trevor, as I indicated in our telephone conversation on April 7, 2011, I did not receive the fax dated March 9, 2011. As I request in the future, please follow up all faxes to me with a letter copy. My client now has provided me with a copy of the letter dated March 9, 2011 by the city council members. I have had an opportunity to review your letter and would make the following kind of proposal. And this is where we're going to bring up the other part, that because this is very similar to what we talked about February 7th. That Ray Goff, on behalf of Charlie's, will pay settlement of $12,000 for any and all issues that remain in our litigation, including violation of the criminal ordinances. Any and all other license fees and city ordinances concerning the disclosure of vendors operating in the businesses known as Charlie's Antique Mall. That Charlie's Antique Mall will purchase a master license of $3,000 each year. In my opinion, the master license, the master license would be in the best interest of all the parties